And we have one more important story. This is Cable News Network, CNN, versus Federal Bureau of Investigation. Memorandum opinion. On May 9th, 2017, Donald Trump fired James Comey as director of the Federal Bureau of Investigation. In the fallout from that event, news rapidly circulated about numerous private conversations between the two men over the preceding months. The exchanges left the former director feeling unnerved and apparently wanting a paper trail. On June 8th, Comey testified publicly that while still in office, he had created several contemporaneous memoranda documenting up to 9 conversations with the president. The content of those memos has since been the subject of intense public speculation and is the focus of these consolidated cases. Plaintiffs, which include various news organizations and nonprofits, all sought copies of the so-called Comey Memos via a tried and true method, the Freedom of Information Act, 5 U.S.C. Section 552 et sequitur. The government denied each request, claiming that the release of these documents would interfere with the Office of Special Counsel's ongoing investigation into links between Russia and Trump's 2016 campaign team. Plaintiffs then brought these suits, and both sides now seek summary judgment. The country, or at least the Beltway, has spent months abuzz about the Comey memos and what they might reveal. Despite rampant media speculation, however, the memos themselves have remained out of public view. The government hopes to keep it that way, but to withhold release under FOIA, it must satisfy 2 elements. First, it must demonstrate the adequacy of the search for relevant documents. Second, it must show that the withheld material falls within one of 9 statutory exemptions. Plaintiffs attack the government's effort at each step. An agency fulfills its obligations under FOIA if it can demonstrate beyond material doubt that its search was reasonably calculated to uncover all relevant documents. The adequacy of an agency's search for documents under FOIA is judged by a standard of reasonableness and depends, not surprisingly, on the facts of each case. Here, the FBI's Records Management Division, which was involved in compiling and preserving the former director's records, first located the memoranda. It passed them along to the National Security and Cyber Law Branch of the FBI's Office of General Counsel, which is responsible for providing legal advice regarding the Russian interference investigation, and thus was already familiar with the relevant records. That group then confirmed the located materials were, in fact, the full set of memos. Just to play it safe, the government also double-checked with the Special Counsel's office, which has since compiled the memos. They, too, concluded that the FBI had located all of Comey's records. In sum, the FBI is confident that it has identified and located the entire collection of documents comprising the Comey memos. The 2 plaintiffs nevertheless remain unconvinced. The Daily Caller and USA Today argue that the agency has not adequately explained its search efforts, variously noting that the FBI did not conduct its search using the standard method of searching its central records system. USA Today says the agency must identify the number of records they located. Neither argument holds water. While querying an electronic database may be appropriate in the mine-run FOIA foray, the requests here center on a discrete set of extraordinarily high-profile and easily identifiable records, namely any memoranda that then-Director Comey wrote documenting his conversations with President Trump. Allowing officials with relevant knowledge of these documents to search for them is reasonable, given the facts of this case. The government avers that it has located all the memos, and plaintiffs' mere speculation that it has not uncovered documents that may exist does not undermine the finding that the agency conducted a reasonable search for them. Nor must the department reveal the exact number of documents located, as it asserts that doing so could reveal sensitive non-public information and compromise the investigation. Whereas here an agency indicates that no additional information concerning an investigation may be publicly disclosed without revealing precisely the information the agency seeks to withhold, the court can properly resolve the issue by an in-camera review. The court, having accepted the invitation for the in-camera review, now sees no reason to doubt the government's search effort. Although the government invokes a slew of exemptions, including 1, 3, 6, 7C, and 7E, to justify the withholding of the memos, it primarily leans on 7A. Because the court deems this last one applicable, it need not address the other exemptions invoked by the government and reserves judgment on whether they too would be supported by withholding the Comey Memos. Judicial review of an asserted Exemption 7 privilege requires a two-part inquiry. As a threshold matter, the court must determine whether the records or information were compiled for law enforcement purposes. If the agency so establishes, then it must demonstrate that a particular subpart of Section 7 applies. Here, it must show that the release of those records could reasonably be expected to interfere with enforcement proceedings. The court discusses. Exemption 7. The government offers two explanations as to why the Comey Memos satisfy Exemption 7. First, it says that they contain information that was originally compiled as part of the FBI's investigation into Russian interference. Second, it indicates that the memos themselves have since been compiled for law enforcement purposes. The court focuses on the latter theory, as it alone would place all portions of the memo within Exemption 7's purview. The DOJ's public briefing suggests that the Comey Memos have been compiled into the ongoing investigation by the special counsel into Russian interference. By way of background, Rod Rosenstein appointed Robert Mueller as special counsel May 17, 2017. The Office of Special Counsel has revealed little about the scope of its investigation, but Rosenstein's initial order authorized Mueller to investigate any links or coordination between the Russian government and individuals associated with the campaign of President Donald Trump, any matters that arose or may arise directly from the investigation, and any matters within the scope of 28 CFR Section 600.4a. Under that section, the special counsel's jurisdiction includes the authority to investigate and prosecute federal crimes committed in the course of and with the intent to interfere with the special counsel's investigation, such as perjury, obstruction of justice, destruction of evidence, intimidation of witnesses. Although the government has been tight-lipped in its briefing about exactly why the special counsel compiled these memos, the first Archie declaration confirms that the office did so for law enforcement purposes in service of that investigation. Without reviewing the declaration, plaintiffs, of course, are somewhat hamstrung in their ability to dispute this position. Instead, they focus their fire on Comey's intent when he first created the memos. CNN, Judicial Watch, Daily Caller argue that the director, by his own admission, penned these memos not in furtherance of an investigation, but to preserve the FBI's integrity. That may be so, but it matters not if the memos were generated on an earlier occasion or for a different purpose. Rather, the Supreme Court has made clear that the objects sought merely must have been compiled when the government invokes the exemption. In other words, Exemption 7 applies to materials originally collected for a benign purpose so long as they were eventually compiled or incorporated into a law enforcement investigatory file. Comey's intent, whatever it was, is irrelevant. The government thus needs to show only that it has since compiled the memos for law enforcement purposes, a bar it easily clears. Plaintiffs try to chip away at the conclusion, but none of their counterparts prove persuasive. First up, CNN correctly points out that in order to rely on 7A, the agency must have compiled the documents before it invoked that exemption on June 16th. In his public testimony, Comey averred on two separate occasions that he had already turned copies of his memos over to special counsel team on June 8th. It stands to reason, then, that the special counsel had compiled them at least by that date. The government has also submitted another ex parte Archie declaration clarifying that the special counsel had indeed done so before June 16th. Next, the Daily Caller highlights that the FBI searched for and located records in archived administrative files rather than the special counsel's files. This is irrelevant. The court turns to whether releasing the memos could reasonably be expected to interfere with enforcement proceedings. In enacting this exemption, Congress recognized that law enforcement agencies had legitimate needs to keep certain records confidential, lest the agencies be hindered in their investigations. Exemption 7A does not require a presently pending enforcement proceeding. Instead, an ongoing investigation triggers 7A. So long as the investigation continues to gather evidence for a possible future case and that case will be jeopardized, Exemption 7A applies. In evaluating the department's Exemption 7A defense, this court must give deference to an agency's predictive judgment of the harm that will result. It cannot act as a rubber stamp simply because the agency asserts disclosure. The court concluded that the DOJ's initial submissions fell short, and after an in-camera review, At the first Archie declaration and the memos themselves, the court asked an attorney to make an on-the-record proffer about the investigation. Having heard this, the court is now fully convinced that the disclosure would be reasonably expected to interfere with the ongoing investigation. In disputing that conclusion, plaintiffs make much of the fact that Comey himself testified about the comments of the memos. In light of those statements, they wonder how much damage release could inflict now. While Comey may have testified about some material, he has never disseminated copies publicly. As the D.C. Circuit held, the fact that information exists in some public form does not mean that official disclosure will not cause harm. As a variant for their prior disclosure argument, plaintiffs argue that the Justice Department has waived any FOIA exemption pursuant to the public domain doctrine. Under that doctrine, materials normally immunized from disclosure lose their protective cloak once disclosed and preserved in a permanent public record. Plaintiffs argue that this is the case here. This court disagrees. The court acknowledges that the situation is rather unprecedented. It is not every day that an FBI director feels the need to memorialize his conversations with a sitting president and that he publicized that he did so. But case law aligns with common sense. The public domain doctrine exists because of the release of a truly public document can do little harm to the agency's interest, and therefore an exemption can serve no purpose. Even if this court stops short of releasing some or all the memos in full, plaintiffs alternatively ask that it require the department to turn over any non-exempt portions. FOIA requires that an agency produce any reasonably segregable portion of a record after deletion of the portions which are exempt. That analysis does not call for a parsing of the Comey memos line by line or segregating material dispersed throughout the document, as plaintiffs suggest. Instead, the emphasis is on segregation of non-exempt material found in logically divisible sections. The government asserts that no logically divisible section is segregable. Indeed, releasing any portion would necessarily reveal their level of detail, as well as any extent to which the records do or do not corroborate Comey's testimony. The court has reviewed the disputed documents and confirmed no portion is reasonably segregable. For the foregoing reasons, the court grants defendants' motion for partial summary judgment and denies plaintiffs' cross motions. What do we think of that? So, we don't get the Comey memos yet. I wasn't expecting them, but just in case someone was, we don't get the Comey memos yet. Not until the Office of Special Counsel Robert Mueller's investigation, Robert Mueller's investigation has concluded, and the documents are deemed no longer being held for a law enforcement purpose. So that's that. What do you think of that?